Thank you. And to your best, if you can try to speak in the microphone. I know there's only 2 microphones for the 5 of you. But Representative Place, you have a question?
To the code enforcement. In your experience, even anecdotally, what's been the primary cause of barrier to getting timely code enforcement? I mean, you talk about, I know you have mentioned that it's all over the place, but is there one particular thing? Are we just talking about inspectors are lazy? Or is it that the administrative procedure to appeal is so long that it's just not timely, it's not happening in a timely manner?
So I think it's a combination of all of that. If you follow the property maintenance code, the appeal process, it defeats the purpose of filing the complaint. And most of the property maintenance complaints we receive around the state are on the owner-occupied single family, which they handle in municipal courts right within the towns. I think the overall treatment of the tenant landlord complaints probably gets overlooked. I think those get lost in the shuffle. I don't think, and I think it's a matter of, again, going back to triaging, identifying the legitimate ones and identifying those that need that immediate response or the delayed response. Another big problem is on those that require the immediate response, the landlord doesn't respond, he's out of town, the roof is leaking, the city has to send someone out to fix the roof. Who pays for that? And I think that's something we need to think about. Our cities and towns, everyone's strapped by budget. Do they want to be doling money out to third-party contractors and then placing a lien on the property? So I think those kind of just have a tendency to linger until the landlord gets around to addressing the problem, and they just kind of bounce.
Okay. And just to follow up to that, outside of different things we've heard in terms of trying to withhold rent and things like that for code violations, are there any other mechanisms for a tenant to get any kind of damages from the landlord for being forced to live in those conditions outside of the tenant landlord handbook? Do they have any other rights to law? And I mean, anybody on the panel, if you know the answer to this, I'd appreciate. But is there any other ability for a tenant who's in a unit that is in gross violation of the codes to, quite frankly, sue their landlord for damages for not timely repairs?
I'll speak to only the building codes. That does not exist.
Okay. All right. So, well, you have an answer.
Well, I was just going to say for lead specifically, we did, when we passed the lead package in 2023, there was a bill that allowed for treble damages for families that had actually been poisoned, and so that is in play. It's a little bit separate, but I did want to just throw that out there for damages.
And that was part of my follow-on. I was getting to that aspect of it. Now dealing with the lead aspect of it. The law's been on the books for 20 years, and I'm just curious from the Department of Health's perspective and from the EG's perspective. I mean, was it that there was no mechanism to enforce it up until recently? Or was it just no one cared to enforce it? It's been on the book. It's been on the books for 20 years, and Department of Health and the AG seem to have been able to, in different ways, impact enforcement of this law. But why is it that we need a registry in order to enforce compliance on something that should have been done, especially when I think the Attorney General's numbers are a little underplayed when they say 1 a day. I think it's more like 3 a day that are diagnosed with lead poisoning. I mean, I'm trying to figure out why is it that we got to this point where no one was enforcing this for the last 20 years. I mean, is that what it is? Just no one was caring to enforce it? Or were there no enforcement mechanisms until the most recent round of legislation was passed?
So the process is, depending upon the child's blood lead level, which direction it goes. So it's up to each of the 39 municipalities and towns to enforce the Lead Hazard Mitigation Act. and that's checking the properties if they have a certificate or not. If a child has a blood level of 5 to 9.9, we send a state inspector to the house. The state inspector will inspect it, and then send a notice to the landlord for mitigation. And if the landlord does not respond to us, then we refer that to the municipality. And some municipalities are very diligent, and others just do not do nothing.
So what you're saying is the AG really doesn't get involved until later on in the process if there is a role?
On the blood levels of 10 plus, we send same thing. We have a inspection. The families are given case management along the way, but there's a first notice of violation, followed by a second notice of violation, and then it's at the second notice of violation we refer to the AG.
That process statutory or regulatory?
Both.
In what way? In what way? I mean, so does the statute establish this two-tier system based on the levels, or is there regulation that established it?
So there's a statute that requires the referral, and then regulation sets the level. But I just want to be clear that that's after the poisoning, and so that's whether or not there's a certificate in place. Most of those units, there's no certificate in place. The vast majority. In some cases, you'll have a certificate in place, but the landlord has allowed the unit to fall into disrepair, and so when the DOH comes out to do the inspection following the poisoning, there are violations present. To answer your question directly, Representative, I think the experience of Maryland that Allison mentioned is really what happened here in Rhode Island. You can have a requirement on the books without some sort of transparency mechanism for enforcement agencies at the state and local level, for tenants themselves to understand whether a landlord is meeting the requirement. I think two things can happen. One is certain landlords will intentionally disregard the requirement. And the other thing that will happen is lots of landlords just might never learn of the requirement. There are a lot of laws on the books that people just don't know about. And so Maryland found that when they put the registry in place, their compliance with the lead certificate that they have, which is actually almost exactly like ours in Rhode Island, just skyrocketed. And so that's what we wanted to do here. And it's what other states have done as well, and other municipalities. So, sadly, I think you sometimes do need compliance forcing mechanisms like this to get compliance.
And I will just add, Central Falls was kind of doing this work. It's a good example of a municipality that was kind of doing a proactive approach. So as Keith mentioned, our efforts at the time before kind of going through the legislative process was really after the child has been poisoned. We've brought 22 lawsuits, 65 units remediated at this point, maybe more since those numbers. But we were doing that at a later time. Central Falls has been kind of doing that work, but it is a lot to put on the municipalities when they don't already have a registry in place. And so now with the registry, it can allow for more transparency of what the housing situation is, and then now we can do that extra enforcement.
Sure, Mr. Conti.
Ed, as far as the Department of Health, your numbers may be skewed on the people who are in compliance because your system online, if I say I have a 3-family and I have lead certificates for 2, I cannot submit that until I get that third one. So there are compliance done partially, but since I can't submit it, you don't have it on your calculations that they're done.
Those would be under the draft properties.
Right.
But this is the phase 1, so we haven't identified them because our focus right now is education.
But I want to listen, you can't submit them even if you wanted to.
Correct.
Because you have to get the whole house. And
but we have all that on record.
Okay, just want to make sure because it didn't seem like you couldn't submit it. So, okay. Second one, the Attorney General's office. In regards to the appointments for the lead that you say now there's all these lead inspectors. Well, the problem is no landlord's going to make 78 phone calls. But I got a solution for you. Basically, it's very simple. It's just like you go online and get a reservation for a restaurant. There should be some online, like everybody's trying, like the code enforcement is trying to get this big website up and running. If they could get something online and it can show, okay, who's available. it'd be quicker to get people to call that one versus one that's already, we're getting dates for March and April right now on some of these lead inspectors.
Yeah, I can't speak to the Department of Health's website setup, but what I can say is even if you call 5 down, you can get through to somebody. So you shouldn't have to call through all 70 people. We did it for the purpose of this, commission hearing and wanting to make sure that we gave an accurate representation. And I will say, a lot of them didn't pick up, but may call back later this afternoon. And so that does happen as well. And
That list, is it online?
So yeah, if you go to lead1978.com and to the left-hand column, is a button for lead inspectors, and that will give the list of the full set of lead
I was
inspectors.
just trying to think of an easy way to get it to the landlord so they know.
Yeah, but the problem is if you do Google Rhode Island lead inspectors, the top 3 businesses above the fold are the ones who are now booked out to March, April, May.
Okay.
But there's not a lot of lead inspectors have websites or are SEO savvy.
Right.
So that's why we refer people to our website to find a lead inspector. And like I said, we've just increased the list in the past 30 days by 30 something lead inspectors.
Thank you.
Representative Morales?
Thank you, Mr. Chair. Mr. Cambio, earlier in your presentation, you had made reference to a centralized complaint portal that tenants would be able to access and report code violations directly in a much more transparent manner. What is the status of that portal in terms of development?
So what we would hope to accomplish would be to mimic the contractor registration portal that's been up and running for several years now. I would welcome the opportunity to come back relatively soon if the commission wants to see it. We could run you through a draft.
So what you're saying is conceptual only. It's only conceptual.
It's can be built very quickly.
Conceptual only now.
So conceptual in that what I'd like to do is work with, which we haven't had the opportunity to do yet, work with DOH to link with their registry. It would be very important to have the registration so that if we received a non-lead complaint, we can identify those who are not registered, and we can identify those who may not have the lead certificate at the same time. So you would have, just like a contractor has, a registration. So your landlord 1, that's your number. So a complaint comes in for landlord 1, we can see, oh, he's registered, he has this certificate, and we're gonna go out and investigate the leaky roof. That also helps investigate the lead complaint that may come in. That doesn't get lost in the shuffle when the building official bounces them over to DOH and it happens. Oh, that's not us, that's DOH.
No, and absolutely. I agree with that approach because it's a lot more uniformed than what we have now. Where all cities and towns are having the different processes in place. Some are less responsive than others, etc. What would you need, if anything, from the legislature in order to accomplish this? Would it be similar to the e-permitting system where there had to be enabling legislation?
Yeah, I think what it would require is similar to the e-permitting legislation and then the planning zoning legislation that was just passed in the last session that says the office of the commissioner shall implement an electronic registration and complaint platform under these requirements.
Other questions?
Thank you. Also for Mr. Cambio, the system that you described for these complaints is, I think, badly needed, and I thank you for that. Question is, how does Rhode Island compare in terms of the role and the location of the building commissioner? And would it make sense for the building commissioner to be in the Department of Housing? How would that kind of impact your work?
Yes, so that's a very good question, one that we've talked about a lot. Prior to the introduction of this Office of the Commissioner, the State Building Office, which is the administrative parts of Contractors Board, design professionals, which are the architects and engineers, and the permitting and plan reviews on state buildings was housed in the State Building Office. with the creation of the Office of the Commissioner, we are now able to bring the code, the uniform code enforcement, education, certification, and hopefully this. So we're kind of, that one component of, which is now under the State Building Office, would probably be much better served and probably better utilized if it were in housing.
Any other questions from anybody on the panel?
So I have a couple questions. Do we have any numbers available regarding the unfortunate lead poisoning of children, differentiating between owner-occupied properties, your house, my house, versus a rental property?
I do not.
Okay. All right. And then I heard some talk about the changing in the law, and I think it was last year went into effect. And we keep seeing the law has been on the books for 20 years. Was there a massive change to the law in the sense that the homeowner occupied exemption was removed? And if so, how many units is that have now become available just in the last year that need to be inspected?
I will say it was a significant change, which is why, our focus on education, that education campaign is why we're focusing on education before enforcement, because it is relatively new, and to equitably enforce fines, first you need a full denominator of the homes. You need to find out, I don't think we have that breakdown yet of how many owner-occupied additional houses or units are going to be affected. But generally, that is why we're taking the approach we're taking to make sure that those smaller landlords, specifically the owner-occupied folks, are fully aware of these requirements and have the opportunity to bring their newly subject to the law units into compliance.
Okay. And then also, with respect to the landlord registry, which I understand applies to all properties, it sounds like resources aren't overly abundant at this point. How are we protecting children with lead in post-1978 properties by having them register?
It's not a requirement that there's no lead requirement for the all landlords. That is a simple, and there's no cost. So it's really light touch, just like a hot dog vendor registers, any business registers with the Secretary of State. You're providing a very, very important and very personal service, which is providing housing and homes for families and particularly children. And so it's very light touch. You enter your contact information, and what it does is allow for tenants to have that contact if there were to be any issue, lead or unrelated, for other housing priorities. That's something that we had a lot of advocates in support of this legislation, not just from the lead component. That was why the Attorney General's office proposed it, but it does support other housing efforts.
Does Maryland have that requirement? It seems like you focused a lot on Maryland. It seems like that was only a pre-1978 list.
That is, yes. In Maryland, it's separate. It's a different list. Yep.
Yeah. Okay. And I guess just the last question I'll have, and we'll time back here, is obviously we want to make sure we reduce lead poisoning as best we can, right? So if we have a situation where we have a non-compliant unit, and there's an owner in there, there's an at-risk occupant in that unit, how is stopping rent collection advancing, remediating that unit? So in other words, if the person is in there and they're not leaving because they can't be evicted and the owner's not fixing it, how do we help that person?
As I said before, one, you don't have to leave the property to get your property inspected, and if you pass, the tenant would never have to leave. You also, if you did have a property that was failing the inspection and for some reason did have to go through that process, if the landlord is going through that process, it will remediate the issue of non-payment of rent. The effort for non-payment of rent is to act as another enforcement mechanism when the landlord knows they're not in compliance, continues to not be in compliance, regardless of the fact that the tenant has brought the notification to their attention.
Yeah, and just to add to that, so I think that the provision in the law that you're referring to is called the Clean Hands provision, which is in Maryland as well. So basically, if a landlord is non-compliant with lead-safe housing requirements, then the tenant can go to court ask a judge if they can put their rent in escrow, and that money can be used to remediate the housing. So it's judicial oversight, which is, I think, exactly what everybody wants in this situation. Nobody wants tenants withholding rent. We want a judge involved so that, frankly, the process works smoothly and that the relationship between the landlord and the tenant can remain intact going forward in the tenancy. And just to respond to your earlier question about owner-occupied units, that law has been in effect now for 18 months. And owner-occupied units were always required to be lead safe. There are property maintenance code requirements that bear on lead. They just weren't required to have the certificate. Those landlords have had 18 months to come into compliance with the lead safe certificate law. So I think it's a little bit, I just think it's really important to note that yes, some number of landlords, probably a significant number of landlords are owner-occupied, needed to get that certificate sometime in the last 18 months. Inspectors have been available, public funding has been available, will be available to do that work. The time is past for people to get those certificates in place and make their housing safe.
So are we saying there's funding available for someone who might need to remediate? Again, because we don't want to displace anybody, right? So if someone is in a unit that needs remediation, you mentioned, there's procedures available. What are those procedures? Is the state providing funding to house these people so this work can be done, or how is that happening?
I can speak to that a little bit. So first of all, there are a few programs, right? And the two that the Department of Health mentioned today were Providence and Woonsocket. There's also a statewide program. And at the AG's office, we've worked to try to reduce red tape at HUD in response to complaints that we got from landlords about, red tape and bureaucracy preventing that funding from getting out to them. We've worked with HUD at the national level to reduce some red tape, and actually that's been successful, and hopefully landlords will find it easier to apply for that funding going forward. In cases where there is, at least through Rhode Island Housing, funding available for the remediation, yes, the program will pay for the rehousing of the tenants if it's necessary to get the certificate. So I'm not sure about the Providence program, Woonsocket program, but at least through the Rhode Island Housing program, yes.
And one other thing, you mentioned that the escrow bill was already in effect, and that's as far as allowing for rents to come back. It's a judicial oversight process, right? You said that?
Here.
Yes.
Yeah, okay. So I think there are two different sections in the bill. There's the most recent, which was passed, which I don't think allows any judicial discretion to release funds unless the unit is in self-compliant, which is different than the other provision which was previously passed. Would it make sense to have both those provisions mirrored, so if there is a situation where there's a non-compliance, a landlord needs the money to fix the unit, that a judge with oversight obviously has the ability to release those funds?
I would have to see the most recent provision, but I think the Attorney General's position when the legislation was put in was that, of course, if a judge orders that money should be released in order to remediate the property, that it should be allowed. That should be allowed.
Yeah, that would make sense, right? Because a straight prohibition is you can't get the money, you can't evict, doesn't help anybody.
Agreed.
Yeah, and I think that's what's in the most recent bill.
I don't have the language,
Yes.
Mr. Rose, but happy to look at it.
Are you talking about
58, section 58.
So subsection G, a landlord may not commence an act to evict for non-payment of rent in any court of competent jurisdiction?
Right, so in that case, if the unit is not compliant and the tenant was not paying, how would they get any rent to conduct any remediation?
So that's a completely different situation. So if a landlord is non-compliant with lead safety requirements, a tenant can affirmatively go to a court and ask a court to hold the rent in escrow, and that money should be released by the judge to remediate the unit if necessary. And then separately, a landlord cannot apply for a non-payment eviction in district court unless the landlord is in compliance with lead safety requirements, in particular the certificate requirement. And again, that's a requirement from the Maryland law. And I think it's really important what that doesn't do. What that does not do is prevent a landlord from evicting somebody who's harassing other tenants, who poses a health and safety risk, right? There can still be evictions for other purposes. But if a tenant is not paying rent, as in the situation where they're going to the court to ask for their rent to be put in escrow, that tenant cannot be evicted for non-payment of rent, right?
What happens if the landlord needs to change all the windows to become in compliance?
Again, they may have to undertake lead safety remediation actions, and the landlord also can. There are other avenues available for the landlord to obtain money from the tenant. They just cannot go to through a non-payment eviction in housing court to evict them.
But they could get possession to conduct those repairs.
Absolutely, and I think that that's a really important thing that our office has heard from over time. That landlords are saying, look, my tenant needs to be out for a day in order to do an inspection, a lead inspection. And our response to that has always been, the law requires the tenant to remove themselves from the premises, I believe with 24 hours notice, but please, 48 hours notice, somebody correct me if I'm wrong, I'm not a housing attorney, with notice. And absolutely, that's the law, absolutely should be followed. In the cases where the Attorney General has had to sue a landlord, we have said to tenants, look, you're gonna have to be out for this amount of time. Sorry if that's an inconvenience, but this is about safety. And your landlord is doing the right thing by undertaking these repairs.
And I am going to jump in at this point. I know that we were scheduled to go till 5. We've gone past that. I just wanted to see if there were any last minute questions. I know that we could go all night on questions, and we appreciate the presentation, the information that's provided. Does anybody have any last final questions or comments? Mr. Weiss?
I just wanted to follow up on one thing. Of course, none of us want kids to get poisoned. Should we focus all our efforts and resources on what the state defines as target housing, and they also defined at-risk occupants? Should we really drill down on the apartments that have children under 6 and pregnant women? I mean, because I know we just doubled the amount of inspectors to 60, but 30 of them are in Connecticut and New Hampshire. And if you do the math, we still have 100,000 certificates we need. And even with 62 inspectors, that's like they have to do 5 inspections a day, 360 days a year. And that's if no one fails. That's the only way we'd ever be able to accomplish that. I think we should really go after the places where kids live, not 0-bedroom units in a historic home where no children reside. Is there any thought on that?
I think I'm going to go back to the first thing you've heard me say probably a dozen times now. They've had over 20 years to comply with this law. I understand the education, and we're, supportive of any education and supportive of, additional inspectors. I don't think there are any Connecticut or Vermont inspectors. Is there? There is? Okay. Connecticut and Massachusetts. But I do think that the messaging is, this work has been law for over 20 years. We have to do this. Similar to, radon testing, other requirements that landlords are required to do. When you are a business entity, say you're a restaurant, if the Department of Health tells you you have to do something, even if you have to shut down that restaurant for 4 days, you have to do that. And so, yes, I do think that landlords should be targeting all properties, because regardless of whether there's a tenant in there right now, these inspections, these lead safe certificates last for 2 years. They must be renewed. Maybe in a year, there's a new tenant that's got a child. Maybe there's a grandparent that's living there and there are no children there, but the grandchildren come over during the day. We can't make these carve outs for kind of the one-off. And I don't mean by one. I understand and recognize that there are other scenarios, but we cannot do that for, a small minority. As you said, there are 100,000 inspections that really need to be done. They had 20 years to do them.
Thank you, Ms. Fonseca. And I'm going to give
I just want to add one thing. There's also a route for a homeowner once they have a lead inspection. If the tenancy doesn't change, the affidavit of visual inspection is where the homeowner or the property owner needs to just take a course and can do any repairs and do a visual inspection and get it notarized and submit that to extend their current lead certificate for 2 years.
And thank you, and I'll give the last word to Ms. Crandall. I know you've had your hand up for a while.
Thank you, appreciate it. So you've mentioned a couple times that even with 20 years of this requirement being on matter of law, that so many landlords are out of compliance. What efforts has your office made to achieve accountability, and how would it impact the work that you do pursuing accountability if tenants were classified as consumers?
So I will touch on this a little bit, but I'd be happy to have Keith Hoffman talk a little bit about this because before his joining the office, this work was not happening. If at all, in the office, maybe a couple of cases, but it really has been spearheaded. One of the things I'll say is we do a lead summit every year. We do a lot of education. We've been talking about this at the State House for over 2 years now, and so we're happy to continue that education. And we have brought cases, and we publicize those, and we issue press releases and press conferences. Keith, if there's anything else I'm missing.
Yeah, so I mean, look, I do. It's definitely not just me. I mean, I definitely disagree with that. I think Attorney General Whitehouse was really behind the Lead Hazard Mitigation Act. During Attorney General Lynch's tenure, there were a lot of cases brought. You need both a kind of functioning Department of Health and a functioning Attorney General's office to do the work, and that doesn't always happen. And so, actually, when Attorney General Noronha came in and found a really great partner in our Department of Health, we were able to start bringing these cases again. I will say that I think you're referencing a recent court decision that held that tenants are not consumers in Superior Court in Rhode Island. Our office disagrees with that decision, and we're going to be appealing it if we haven't already. And our position remains that tenants are consumers, that the lead certificate is a basic consumer protection mechanism to ensure that tenants know what they're getting when they rent housing. So, but thank you for the question.
Thank you. I just want to take an opportunity to say thank you to all the presenters again for the information you've provided, the documentation, and taking time to answer questions. I know we kept you a little after 5, so we certainly appreciate it, but we all acknowledge that this is a important venture that we need to fully discuss and vet and vent. So thank you again. If you have any additional material that you'd like us to consider, please don't hesitate to pass it on to Christy Durant, and she'll make sure that we all get it. The next meeting will be scheduled for January 16th, 2025. But at this time, do I have a motion to adjourn?
So moved.
Thank you. This meeting will be adjourned. Thank you, everyone.